Good morning and welcome to the August 25th, 2016 Zoning Board of Adjustment meeting. If any member of the audience wishes to speak to an item on the agenda, there are speaker request forms to the left of the dais. Please fill out the request with the agenda number of the item you wish to speak to and hand it to the secretary. We'd also like to ask that if any member of the audience has a cell phone or other electronic device, that you either turn it off or turn the ringer to silent. If you need to take a call, please step out to the hallway so that the meeting will not be disrupted. Now we'll look at item number 1, approval of the May 26th Zoning Board of Adjustment minutes. Second. Linda made the motion to approve. Steve seconded. All those in favor, please say aye. Aye. Opposed? Motion carries. Item number 2.
Item number 2 is 16 VA 004, a variance request to allow a 6-foot high fence in lieu of a 4-foot high fence in the second front yard of property located at 3100 Iris. Property is zoned low-density residential district. The uniqueness of this property is that there are 3 frontages on Iris, Crocus, and Park Drive. The applicant, or the ordinance allows a 6-foot high fence in the second front yard when it's set back 10 feet from the property line. The applicant is wanting to have that fence within within that 10 feet. Aerial view of the property. This is the rear yard. There's a detached garage, single-family home, a retaining wall or wall at this point, and that's where the fence is proposed. Future land use is low-density residential. Crocus and Park Drive are collector streets. Site plan in this pink line is, where it doesn't show up very well, but this is where the fence is proposed. Back to the property line. And the slide that kept showing up, this is one example of what the applicant would prefer to have as a fence. And then another example, 6-foot high fence, just wood. This is taking a look at the property from Iris looking east, looking down Iris to the south, across the street to the west, looking down Crocus to the west. We're in a single-family residential area. This is looking along Crocus to the east towards Park Drive. Notice there's some elevation going up here. This is looking south on Park Drive from the location of the fence. Currently you can see the wall. It'll be in this area here. This is looking at from the top. This is where the proposed fence is going to be located, looking to the north along Park Drive at the intersection. So you can see there is some distance from the intersection. This is looking at the stop sign to the south along Park Drive. So you can see that you can't even see where the fence is going to be. It's not going to intrude into any site triangles and cause issues with traffic. This is looking from Park Drive on the east side, looking back towards the property, location of the fence in this area, and the how clear it is with the from the intersection. And then again, looking from Park Drive north towards the intersection, the fence will be up here. It's not intruding into the site triangle. The uniqueness of the property is that there are 3 frontages. Typically, the property has 1 frontage on a street. The ordinance has the the exception to allow a 6-foot fence in a second front yard for corner lots. This is a unique one in that it has a third street frontage, which is along what would be the rear yard of the property. It doesn't intrude into any site triangles causing any public safety issues, and staff recommends that the variance be granted with the stipulation that the applicant identify where the property pins are located and ensure that the fence is not located within the right-of-way. With that, are there any questions for staff?
Any,
With the stipulation.
Karen made the motion to approve with stipulation. Linda seconded that motion. Any discussion on the motion?
Could the motion please include the reason for granting the variance? I think the staff report says the special circumstances, given that the lot is surrounded by streets on 3 sides.
Thank you, Carla. That's part of my motion. Forgot that part.
Seeing no further discussion on the motion, all those in favor, please say aye. Aye. Opposed? Motion carries. Any further items on zoning board of adjustment? Discussion otherwise? Look for a motion to adjourn the zoning board of adjustment. Steve made the motion, Jan seconded. All those in favor, please say aye. Zoning Board of Adjustment is now adjourned. So we'll move on to the Rapid City Planning Commission meeting for August 25th. Again, any audience member that wishes to speak to an item on this agenda, please grab a speaker request form and turn it into the secretary. We'll start with the consent calendar. Items 1 through 7 have been placed on the consent calendar and may be approved as a group. Action will be taken on all consent items in accordance with staff's recommendation by a single vote. Any item may be removed from the consent calendar by any planning commissioner, staff member, or audience member for separate consideration at this time. The findings of this planning commission are recommendations to the city council. The city council will make the final decision with the exception of the following items. Item 4, 16 PD 038, and item 6, 16 UR 018. Rapid City Planning Commission's actions on these items are final unless any party appeals that decision to the Rapid City Council. All appeals must be submitted in writing to the Community Planning and Development Services Department by close of business on the 7th full calendar day following action by the Planning Commission. Are there any items 1 through 7 staff would like to remove?
Number 5, please.
Any items 1 through 7 the Planning Commission would like removed?
3 and 4.
And any items 1 through 7 that any audience member would like removed?
Move to approve with exception of items 3, 4, and 5.
2, 3, 4, and 5.
That you just needed to be abstained from it.
Oh, okay.
So 3, 4, and 5.
Okay, so we're going to vote on items 1, 2, 6, and 7, and Kim's going to abstain. Right, okay. Steve, would you just revise your motion to 1, 6, and 7?
Move to approve 1, 6, and 7.
Thank you. Steve made the motion. Karen seconded. All those in favor, please say aye. Item 2, Kim is going to abstain from.
Second.
Linda made the motion to approve. Steve seconded that motion. All those in favor, please say aye.
Aye.
Mr. Chair, I'll be abstaining from 3 and 4.
Okay. Jan made the motion on 3 and 4. Andy abstains. Is there a second? Steve seconded. All those in favor of approving items 3 and 4? say aye. Aye. Opposed? Items 3 and 4 carry with Andy's abstention. 5.
Yes, thank you, Mr. Chair. Item number 5 is a preliminary subdivision plan to combine 2 properties out at Elks Country Estates into one large lot. I pulled this item just to do some minor changes to the stipulations, and I did provide a handout on the dais today. Stipulation number 2, it's noting that there's a portion of a sidewalk that's missing along Jolly Lane, and it currently states that a variance would be needed to waive that. It's actually an exception. It's a different process than a variance. An exception is looked at administratively, so we wanted to make that clarification to give good direction to the consultant. In addition, item number 7, it speaks to the issue of a sewer main being constructed. We're anticipating in 2018 that would allow for the decommission of the Jolly Lane lift station and would improve sewer capacity to the area. The way the stipulation currently reads that it's required that the applicant provide the city with an easement, and we really can't do that. We're encouraging them to coordinate with the city, and in visiting with the consultant, I don't think that's going to be an issue, but I wanted to clarify that it is to encourage and not require. So with those 2 changes, we are recommending that this item be approved with the stipulations as handed out on the dais.
Move to approve with said stipulation.
Steve made the motion to approve with the revised stipulations. Linda seconded. Karen has a comment.
Thank you. I might have some questions for Cale out there representing the applicant, or Vicky, I'm not sure. This is a piece of property that has, it's owned by the Elks Grand Lodge, and it is the property where the hole number 11 and 12 are located. And at one time, Dennis Zanstra graciously decided to build the bathroom for the golfers out there, and the idea was to then transfer on his property and then transfer that land over to the Elks so they could have that for their use and pay the property taxes on it and that kind of thing, which was very well appreciated by the golfers. And as a golfer out there myself, there's some others who have some questions about the process, not what's happening, but more of the process. And I did talk with Vicky about it, trying to understand some of the process, but there's questions I didn't ask you, and I apologize for that. Once this is approved, it goes to City Council for their approval, and then the items that are stipulated in there, I assume that Zanstra is going to do those items, and it's not required by the Elks to do any of that thing, and I guess I'm asking Cale that question.
Yes, ma'am. So realistically, just as you stated, they built this shelter. It's on a residential lot right now. The idea being to combine it with the golf course so that the shelter that serves the golf course lies on golf course property. The items that we've asked for an exception to are to construct the section line highway that abuts the golf course. We're working through that process right now. The only other item laying out there would be the sidewalk along Jolly Lane, and we're still working through that. That's not a golf course. It's not an item that the golf course is going to have to pick up the tab on it.
Okay, and all the engineering things that you will be doing, I assume Zanstra is paying for that?
Zanstra's paying for all that.
Yeah. Once it's approved and goes through council and you get ready to do the final plat, then the Elks and you also have to sign the application to do the final plat, if I understand that correctly.
Yeah, so it's a joint application. So the Elks signs the applications and Zanstra signs the applications. Now ultimately what's going to happen is we plat it into the Elks' lot, and then Zanstra gives a deed to that parcel. I guess it doesn't exist, but he quitclaims any right to that former residential lot once it's platted into the golf course.
Okay, can you explain that process of how that part is transferred over?
Yeah, sure. So you've got 2 parcels right now.
Right.
I've drawn a plat to combine them into one parcel with a new legal description. So what'll happen is we're going to get this plat through final plat. We'll file the Mylar. Then the former residential lot and the tract that the golf course is on, they're no longer going to exist because they have a new legal description. So they'll rewrite the deed, and the deed will reflect the new legal description on the golf course plus the residential lot.
that boundary. And then Zanster will quit claim any deed to the previous residential lot to the golf course.
Okay, and to separate those two pieces of property, we'll go through a lot line adjustment, is that?
No, this is the plat right now.
Mr. Chair?
Yeah.
So point of clarification, if in the future there's any property then that would be future subdivided back to Zanstra where he still got some acreage back, but the golf course retained the ownership of the bathroom facility, that would qualify as a lot line adjustment plat because they have created this into one legally transferable parcel, and there is an adjacent lot that could work to that benefit. Until we see that application, we're not sure if that's the route they're going to take, but it would be a viable option.
Okay. Is that something that you folks are looking at, or?
I think there's a wedge of property along Jolly Lane that the golf course is not interested in.
Right,
It's a small wedge, I want to say like 1/10 of an acre, that they're looking at ultimately moving into one of the residential lots that butts the golf course. Yes.
okay, that's what I understood.
It's a currently platted lot. Yes.
Yeah, okay, that's kind of what I understood, and that was some of the questions that we had and some of the golfers
so
had, so.
I apologize for the confusion. I guess I didn't know the route that this was going. But,
Oh, okay, I just wanted to know the legal steps that are going to be taken once this is approved and it moves forward, and so everybody has an understanding of what's happening. I don't want some of the golfers out there to think that hole 12 is going to be gone or something
no.
like that, so.
No, we're just going to put basically the shelter back into the golf course where it belongs.
Okay, gotcha, and I appreciate that, and the golfers do too, so thank you, and thanks for Zanstra for doing that. Thanks.
So we have a motion on the floor on item 5? I think we already have one on the floor, yep. All those in favor of item 5 per the revised stipulations, please say aye. Aye. Opposed? Motion carries. Item number 8.
Thank you. Item number 8 is 16 PD 034, a request for a final plan development to allow multifamily housing to be constructed on approximately 4.17 acres of property zoned medium-density residential district and office commercial district. This is located just to the southeast of the intersection of Enchantment Road and Stumer Road, also known as west of the new Walmart. Let me take you through some slides. Zoning on the property, as you can see, medium-density residential district with a small corner of the property located in the office commercial district. You should note that multifamily housing is a permitted use in the office commercial district, just as it is in the medium-density residential district. In this instance, the property is located in a planned development designation, and because of the multiple structures located on the lot, that would also require a planned development. Property is void of structural development today. We do have the Eagle Ridge Apartments located to the south, so we do have an area transitioning between single-family residences to the north and to the west, and multifamily housing located between that single-family residential and the commercial district located to the south and to the east. Future land use shows this is appropriate for urban neighborhood. Apartments are considered an appropriate use in the urban neighborhood district. And the future land use plan shows Katrin and Fifth, our principal arterial streets, Enchantment Road to the northwest is identified as a collector street. The applicant is proposing one exception as a part of this request. That exception is to allow a maximum 7-foot tall fence to be located in the front yard setback along Stumer Road. I neglected to include an elevation of that, but I do have one that I can show you on the overhead here in just a minute. The proposed development is a gated community. They're proposing a 6-foot tall, or actually a 7-foot tall wrought iron and stone fence along Stumer Road, a 6-foot tall white vinyl fence to be located on the property line on all the balance of property lines to the northwest and east. The development's comprised of 4 structures totaling 72 units to be built over a period of 5 years in 3 phases. The first phase are these apartment buildings here and here, as well as the accompanying parking. And phase 2 will include a third building. Phase 3 will include the fourth building and a community room located there, as well as the balance of the parking. The applicant is proposing to meet all landscaping requirements, and they are in excess of the minimum required parking by about 70 spaces. Landscaping plan on the property. We do have single-family residences or townhomes that are located to the northwest of the property today. So the applicant is proposing a combination of landscaping and a screening fence to try and buffer the potential impacts of the apartment complex. So a 6-foot-tall white vinyl screening fence along retaining walls to be located along this property line, and then underneath the pen mark there, they are proposing landscape shrubs to try and help mitigate some of the potential sound impacts of that as well. Elevations of the building. Building will be 35 feet tall. One thing to note here, a little known aspect of the Rapid City Municipal Code, the height of a building with a gambrel roof such as this is determined to the midpoint of the ridge, or the line between the roof and the eave. So this midpoint right here, and that's important because that midpoint, as they're measuring on these apartment buildings, is 35 feet, which is allowed, or the maximum that's allowed by Rapid City Municipal Code. So they do meet their building height requirements as part of this. Look at the property today with the sign posted. This is a look to the north and west towards the single-family residential neighborhood. You can see some of the townhomes there as well. This is actually the access point to the Eagle Ridge Apartments located to the south. The thing to note here is that the driveway for this apartment complex and the location of the gate is going to be located immediately across the street from this access point. So you get an idea where the driveway is going to be at, somewhere in that area there. Look, Stumer Road to the east, you can see the roof line of the new Walmart to give you an idea of where the apartment buildings will be in location to that. The existing Eagle Ridge Apartments, look from the Eagle Ridge onto the site. Again, you can get an idea of the location of those townhomes. The three apartment buildings will be located basically running in the same line on this property. Another look onto the site, just to give you a sense of where those single-family residences are in relationship to the rest of the property, as well as the rest of the proposed development in relationship to the commercial district around the new Walmart. As I noted before, they are proposing one exception to allow a maximum 7-foot tall fence to be located in the front yard setback in lieu of a 4-foot tall fence, which would normally be permitted for multifamily housing. Elevation showing what they're proposing to build. The wrought iron fence is 6-foot tall. The stone caps, the stone features there are 7-foot tall, so they have asked for that exception to increase the permitted height from 4 foot to 7 foot. The proposed vinyl fencing, or white vinyl fencing that'll be around the balance of the property will be designed like this. And the 6-foot does meet with the requirements for fencing in the medium density residential district. Staff, worked closely with the applicant throughout this to ensure that the development that was being brought forward met with all the requirements of the Rapid City Municipal Code, and that the exceptions that they were asking for had a definite purpose. And in this case, that definite purpose is to add a security measure and an aesthetic feature to these apartments. The screening fence will ensure that this impact is mitigated to the greatest extent possible, or the impact of this development is mitigated to the greatest extent possible on the residential neighborhood around it. The applicants worked very hard to ensure that the minimum development standards are being met as a part of this, and I think it's paid off in the design, and they've provided us with a good design which should be compatible with the neighborhoods. Staff is recommending that this application be approved with the stipulations noted in the staff report. We do have representative from the property owners here available for questions, and staff is available for questions at this time.
Thank you, Robert. Any questions?
Move to approve.
Steve made the motion to approve. Linda seconded per the stipulations as noted. Any discussion on that motion? Seeing none, all those in favor, please say aye.
Aye.
Aye. Opposed? Motion carries. Item number 9.
Item number 9 is a final plan development to construct additional parking for the West Hills Village, retirement village. We saw a initial plan development and rezones, the rezones from MDR to LDR for this area here and to the south. And the initial plan development was to construct an expansion of the West Hills Village as well as additional parking. There were many stipulations of approval with that initial plan development, and we'll get to some of that through the application. Aerial view showing the property. What the applicant is proposing to do is construct additional parking in this northwest corner where there is some existing parking. It's a total of 36 spaces in an area where it'll be replacing 14 parking spaces, which will give us a net gain of 22 parking spaces. The intent of adding the parking is to offset losing some parking on this east side of the property when they come in to do the phase 2, which is the construction of the assisted living expansion. Future land use shows property is suitable for urban neighborhood, and assisted living is identified as a permitted or acceptable use. 5th Street is identified as an arterial street. One of the other things that the applicant is proposing is to revise the phasing plan. Originally, the assisted living expansion was phase 1, the parking was phase 2, and these townhomes to the south were phase 3. What's happened is the parking will now be phase 1, the expansion phase 2, and townhomes to the south phase 3. So this final plan development is specifically for this parking on the northwest corner. A major amendment or a final plan development will be required for phase 2 and phase 3 if they come in separately or together, but they will be required. So close up showing the proposed parking. They are providing landscaping for this area. One of the major concerns when we looked at this as an initial plan development was drainage on the property. One of the stipulations of approval of the initial was that a master drainage plan be provided for the entire campus. That will still be required as to be provided when the assisted living or the townhomes comes in. The issue with this is there is an existing drainage, and the proposed parking is being accommodated with what's being proposed. So we didn't require a master drainage plan with this submittal. However, we will require it for all these submittals in the future. Showing existing and on the left and proposed the change. Again, this is mainly to accommodate losing some parking with the future phase 2 construction of that assisted living. This is looking from the intersection of 5th Street and Texas Street into the site. West Hills Village sign is posted on the property. Looking along Texas Street back towards the 5th Street intersection to the west. and to the east along Texas Street. So we got apartment living down here, and then further down will be where the single family and the assisted living expansion will be located. Looking south along 5th Street and to the north, and at the 5th Street and Texas Street intersection looking west. Here we have, this is the row of existing parking, which are the 14 spaces, so it'll be constructed a little bit out from there, the total of 36, net gain of 22. You'll notice in the staff report, we do have all the exceptions from the initial plan development, which are still will be required with further submittals. This final plan development is only for approval of the parking lot expansion and does not include the approval of the assisted living expansion or the townhomes, which will have to come in as a major amendment or their own final plan development. With that, staff recommends approval with the associated stipulations and available for questions.
Thanks, Fletcher. Any questions or comments on this?
I'll be abstaining.
Okay.
Second.
I'm sorry, who made the motion? Linda? Linda made the motion to approve with the staff stipulations. Steve seconded that motion. Andy and Kim are abstaining from this item. Karen has a question.
To work here. Thank you. Fletcher, I just have a question, and it doesn't affect this lot, I don't think, or the parking. But in the stipulations, it said something about closing off one of the accesses on 5th Street.
Yes, that was one of the stipulations from the initial plan development. It's basically a reminder. They had submitted the revised phasing plan, which still showed an access on 5th Street to the townhomes to the south. Let me pull that up and show you. Well, it's actually been removed on this one, it looks like, so that's great. There was an access approach at this location, and then there's an existing and a proposed along Texas Street, and the stipulation was that they either remove one of the approaches or get an exception to allow the approach.
Okay. That was my question. I looked at the map and I'm going, I didn't see an access on 5th Street. So that access is still there, but on the map it just says it's not going to be there. Is that?
They've apparently removed it, and I didn't take close enough look at that
That's okay.
particular
I was
area.
just a little confused, so thank you.
Any further questions or comments on the motion? Seeing none, all those in favor, please say aye. 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 Opposed? Item carries with Andy and Kim abstaining. Item number 10.
Item number 10 is a final plan development overlay to allow a daycare in the low-density residential district. Properties located at 4804 Elmer, located at the intersection of Aurora Drive and Elmer Street. Property is zoned low-density residential district. Aerial view of the property, there's a single-family home with an attached garage located on the property. Currently, the applicant is operating a family daycare with up to 12, watching up to 12 children. That is allowed as a home occupation in the low-density residential district. The applicant is proposing to up the number of children from 12 to 20, which requires a conditional use permit for a child care center or daycare in the low-density residential district. The applicant is requesting an exception, or two exceptions. One, there is an existing, the existing play area is the backyard of the single-family home with a fence that goes up to 1 foot from the property line. The Chapter 1750 of the Rapid City Municipal Code requires that a minimum 25-foot setback to the play area be provided. As this is an existing play area fenced off and we're not too close to any major roadways, and that the excuse me, that the streets in this area are local streets, neighborhood streets. Staff's recommending approval of that exception request. The other exception request is to reduce the minimum required parking from 5 to 4. The dwelling itself requires 2 parking spaces, which are located within the attached garage. The applicant has indicated that there will be an employee, which requires an additional parking space, and has indicated that one of the spaces in the driveway will be utilized for that, and that there is a space required for, or 2 spaces required for the number of children that will be at the home. 1 space would be the other spot in the driveway, and the applicant is requesting that the second space required be waived or get an exception to. The justification for this is that the applicant has indicated that there are staggered drop-off and pickup times, which should mitigate the need for the additional parking. So the pickup times are between 6:30 a.m. and, or drop-off times are between 6:30 a.m. and 9:30 a.m. So we're not going to have 20 cars showing up at the same time, hopefully, and then pickup times in the afternoon being from 3 p.m. to 5:30 p.m. Staff is recommending to approve this proposed exception to reduce the parking. However, you'll notice that in the attachments for this item, there are some emails from neighbors regarding, in opposition to the request, with part of the opposition being that there is a lot of traffic in this area due to middle school elementary school being located along Homestead Street, which is approximately 3 blocks to the north. Also on the dais before you was a email that was received yesterday, which is also in opposition to the proposed request. It's something for you to take into account. I don't believe anyone's here from the neighborhood to speak against this. They did, however, bring these in because these are local streets and the staggered drop-off times being proposed. Staff is still recommending that the exception be granted. Future land use properties, urban neighborhood. Here we have the major street plan. Unfortunately, we didn't get Homestead Street will be to the north where the elementary school is. Site plan of the property, and then interior showing parts of the house that are going to be used for the proposed daycare. This is looking north from close to the intersection of Elmer and Aurora. You can see the backyard, sign posted. There is a car parked in the along the street in the area. Looking south across the street to the east along Elmer, single-family neighborhood. Looking directly to the next door to the property. This is the garage and the spot which would be used for the employee. Looking towards the intersection to the west of Aurora and Elmer, and looking south along Aurora and to the north, and we can see where the location of the existing fenced play area, and looking into that fenced area and specifically into it. They'd have to move a lot of the equipment in order to accommodate the 25-foot setback. With that, staff is recommending that the final plan development be approved with stipulations. Good thing to know is that the applicant is working with the Rapid City Fire Department to fire sprinkler protect the structure, and that isn't a requirement of this application. So with that, are there any questions for staff?
Thank you, Fletcher. Any questions? Jan?
Has any consideration been given to the, I understand the staggered drop-off and pickup, but has any consideration been given by anyone to the safety of children who, should that plan not work as designed, would be running across the street or up through the yards or whatever to go to the daycare or go to their parents' cars?
Mr. Chair?
Vicki?
It's a great question, Jan, and something that's always difficult for staff when we're looking at daycare centers in a residential house. We have them throughout the city. They're a needed commodity for every community. We like to keep our children close to home if we can, minimize their travel time. What we have typically looked for and what you as the Planning Commission have required is that the residential parking be inside the garage and that there be a minimum of 2 off-street parking spaces for the children to load and unload. The other thing we look at is street frontage to the residence so that those children can be loaded and unloaded from a car, even if it is on the street side, but they're not crossing the street. In this case, this is a corner lot, so we actually have the opportunity for the parents to use both sides of that corner of that property to get their children in and out. When I visited with the applicant as he was bringing this in, one of the things that we talked about was our concern about the parking. And what was noted is that since he works outside of the home all day long, and because of the number of children, they would have one outside employee, that employee would actually park in the garage in his absence, freeing up 2 parking spaces on the property itself. So that is definitely a minimum that we would want to see happen as a part of this. And I would just like to also reiterate that if there is concerns or complaints that this congestion worsens or that there is a concern from the neighborhood that they or children are being at risk, through the conditional use permit process, if a complaint is filed, we have the ability to bring this item back before you for review, and we will certainly do that.
Thank you, Vicki. Steve?
Yeah, I noticed when I was looking on there, I think it was at Aurora Drive that runs along the side of the house.
Yes.
Yeah, I mean, I looked and it's pretty empty there. Almost to me, it seemed like it would be almost better to have the employee park there, leave the 2 spaces open. I understand for city purposes, we got to sign it. But I'm looking at, in my neighborhood, I got cars parked on both sides of the streets all up and down the road all day long, every day. This one's pretty empty. I'm looking at that. And that way you'd have two spaces for them to safely drop the kids off and pick them up. So just my thought process is I'd almost rather the employee, it's up to them. If it's me running that, I'd have my employee parked there and I have the front space for my customers coming and going. Because I'm with Jan, I'm more concerned about the safety of the children. I'm looking at this long road there that, every neighborhood, people park along the side. It's legal to park next to the curb. So just my thought process anyway. Thank you.
Thanks, Steve. Karen?
And I concur with some of the issues. I think the parking is the issue, and I picked up my granddaughter for a lot of times up there at East Middle School and elementary school up there when she was there. And it is just flooded with kids, which is good because the school is right next to neighborhoods and the kids can walk, and so there's a lot of kids in that neighborhood, and I've been, you have to drive very careful to go through there. So I guess my concern is too that people come and go, and if you're going to have your kids there and drop kids off, I would hope that they would do it judiciously and make sure that they're not trying to, hog the parking spaces. And I think part of it too is, when you get in a hurry and parents are going to work and they're trying to drop off their kids, and they might park right next to the sidewalk or right up, where your sidewalk crossing is, right, and it is hard to see around that corner when you're driving. So I don't know if there's a way you can. You mentioned that if they have some complaints, they can come back to us. How does that work?
So If they do not provide adequate parking and it creates traffic congestion, and again, if you're parking too close to an intersection, that's something that the police department can get involved in too. If it's known that there's been tickets issued, et cetera, then as with any conditional use permit, if they're not complying with what their operational plan or with the stipulations of approval, then we have the opportunity to bring this back before you, the Planning Commission, for a revocation consideration.
Okay, that's a strong thing to do, I think. And I know in some conditional use permits, you put a time frame on there, so you review it in a year or something like that. And I don't know that this needs that or not, but that would be less obtrusive than having a revocation, wouldn't it?
And at that review, that might be your decision. You certainly can add that. There's one other instance that I recall in all the years I've been here that we've done a review, and you probably are familiar with that one, Karen. It's the Cleary Building. Certainly you have the option of identifying that you would like to review this one in X number of months, let's say. The difficulty is that if you approve this and they go out and they open up their business and now parents have got their children coming here and you review it a second time to revoke it, it does put a hardship on the business, on families, et cetera. But it is an option. You can certainly add the stipulation that you would like this item reviewed in a set period of time, and we will track that and bring that back before you.
Okay. I guess I'm not saying that we should do that. I just think that is an option. But if people do park next to the other street, Aurora, if they're on Elmer and they park next to so close to the intersection that it does cause some issues, I would hope that the neighbors would then call the police department and have them start complaining about that so that there is some tickets out there. I think that would help a lot. So, okay, thank you.
John?
Thank you, Mr. Chair. Just a couple of questions, and I don't know whether you had a chance to do this. Is there any regulation in daycare with the number of adults in supervision for the number of kids that are in there? In other words, they indicate one employee for the current number of children that are in there, and I assume one of the occupants of the dwelling is the other employee. Will raising the number to 20 increase employment?
That's regulated by the state, and that's why we always stipulate that it has to meet all state regulations. Maybe since the operator of the daycare is in the audience today, maybe she could share with you what the state requires of her for adult per child ratio. If you could come to the podium, identify yourself, and assist us with that question.
Hi, Brenda Showalter. There would be, for up to 20, you can have one employee for 5 children under 1, and then another employee for 1 to 3, and then over 3 it would be 10 preschool. So basically what I would try to do increase would be preschool. So yes.
So it depends on the age of the children, the staffing requirements.
But yes, there would be another one if there was the 20.
Right now, the staffing requirements is for 1 person for 12, and then it increases for the additional 8, depending on the age of the children.
So in the determination of the parking space, with the increase to 20, it's 2 parking spaces for employees, is that correct?
Yes, if we have the 20, yes.
So what we're approving today is to have them with 1 additional employee. And so that may not allow them to have 20 children on the property if the age would require more employees than 2. So what you're approving today is an operational plan that says that the resident of the facility will be the daycare provider and 1 outside employee. They'll have up to 20 children. But if they have smaller children where it would require 3 employees, then they could not have that many children as a part of the daycare.
Which is not the plan.
And just, excuse me, one follow-up question. Do you have volunteers that come to the facility and staff in, if you will, as volunteers?
No, I don't. I actually just heard that there were volunteers that do that. And so I was going to check into that more.
Mr. Chair?
Not currently.
That is not a part of this operational plan. That would again trigger additional parking. And if that were to be added in, we would have to bring this back before the Planning Commission to review the parking again. So I think we need to make it very clear that any change in the operational plan as presented today is going to be a major amendment, and you, the Planning Commission, will have an opportunity to look at that. Because again, it all goes to parking, and this one's on the line as to whether or not this is going to be appropriate with 20 children and 2 employees. Anything that triggers additional parking needs to be brought back before the Planning Commission.
Thanks, Vicki. Is that clear to both of you as the applicants?
Yes.
And then one follow-up point, if I may, Mr. Chair. In the letter that we have on the dais this morning, one of the neighbors states that the garage is not being used as a parking place for you, I guess. Is the garage, can the cars be parked in the garage?
Yes, cars can. There's one in there right now. I just never had, because I never had an issue with it. I didn't know there was a problem. I parked in the driveway. But I can start parking in there.
Well, I'm just curious if
So-
we're...
Yeah, just a matter of habit. We have
Yeah,
not been
I just-
utilizing the.
Mr. Chair?
Yes.
In visiting with the applicant as he brought this in and had our discussions, he identified that there are 2 parking spaces in the garage, one for his wife and one for the employee when he's outside of the home working. And so that is what must be done as a part of this. And we have indicated that this may be one that staff will actually go out and inspect.
Okay.
Thank you.
Steve?
You know, years ago, my ex-wife ran a daycare out of our home. And that's why I kind of like Karen's idea of the follow-up check on that, because we'd had issues with parking, of course, the neighbors, and then sometimes the people show up and they park in front of my neighbor's driveway and stuff. So it put the onus on us at the home to make sure my customers knew what was going on, and I kind of monitored that when I was there, and Marie did too. So it really made us aware of what was going on, because I didn't want to upset my neighbors. They were friends of mine. And so I worked with them, and I worked with so every person that came in, we had a thing they signed, a parking rule, way we call it. So I'd suggest you guys do the same thing. We had them sign this parking waiver, because it affects your business. If it comes back and things aren't going right, this group here, the Planning Commission, can take that away from you, which is your livelihood. And I respect what you're doing. It's very well needed. So I'm willing to approve this, but you need to understand where your neighbors are coming from. And like I said, we worked really well with our neighbors. At first it was difficult because they're upset at us, and then when we started working with those who were dropping their kids off, we never had a problem from that point going forward.
Okay.
So that's just my comment, I guess.
Thank you, Steve. I guess I would echo that. From personal experience, I've done some stupid things parking to drop my kids off at places. Every parent does that. Even though, your main focus has to be on what happens inside your daycare, you need to take responsibility for that intersection, because it's not just your clients' kids or your kids, it's the school kids who are using the crosswalk.
Exactly.
And you need to protect that corner from being parked on and visibility lost.
Exactly.
I lost my screen, so I don't know if there's any other comments, questions. See, it doesn't like it.
Doesn't like his job.
Doesn't like it. Any, seeing no further, I'd look for a motion
Move
on
to
that.
approve.
Steve made the motion to approve per the stipulations. Karen seconded that motion. All those in favor of that motion, please say aye. Aye. Opposed? Motion carries with Linda in opposition. Item number 11.
Thank you. Item number 11 is an ordinance amendment to adopt regulations governing short-term rentals. by amending Chapter 17 of the Rapid City Municipal Code. A little history to refresh your memories. Some of you are new. 2015, the Planning Commission approved a conditional use permit to allow a bed and breakfast to be located on properties owned, as I recall, as low-density residential district. That decision was appealed to City Council and started a discussion regarding short-term rentals located within the city. Following that, staff at that time started receiving phone calls at least weekly, sometimes multiple phone calls in a week, regarding questions on Airbnb and VRBO and some of these other short-term rental online listing sites that were offering accommodations in private residences for a charge. Existing city code allowed for bed and breakfast as a conditional use in residential districts with certain criteria to be met. And that would go before you as a review, and that's how that original conditional use permit for a bed and breakfast came before you. That particular process didn't fit the way short-term rentals are actually operating in this city and across the country, we found. And we also saw that it became very difficult for these things to operate in the quick, efficient, smooth manner that people expect from internet-operated businesses today. City Council directed staff at that time to pursue an ordinance to regulate short-term rentals, and that's what we brought you here today. In the past, when I've noted or seen these come forward, a large change like this, we've gone specifically through each section of the code and how it would be affected. We have that available and we can answer those questions for you, but I think it would be easier if I just gave you just a quick rundown of how short-term rentals, incorporating this into the ordinance, would go. Short-term rentals are going to be essentially classified as one of two uses: a bed and breakfast or a vacation home rental. The difference between the two is that a bed and breakfast would have a property manager or property owner on site, living in the residence at the same time that they were providing accommodations for guests in guest rooms and for a charge. Amenities may or may not be included as a part of this. So a typical bed and breakfast, a meal had to be provided. The ordinance would be changing to not require that a meal be provided, although amenities such as meals or other accommodations certainly be available for them. Conversely, a vacation home rental, different type of short-term rental overall. A vacation home rental would be one in where the property owner is leaving and renting out their home for a short-term basis, the entirety of the home, for a specific amount of time. They would not be providing amenities. They would not be on the property, living on the property at the same time that they are renting the property out. That's important to note because the size of these operations would dictate what type of action is going to be required. Okay, so with that important distinction in place, what staff is bringing forward basically lines up like this. Any short-term rental that is operating for less than 14 calendar days per year is not subject to these regulations. That is identified in South Dakota codified law today, and it will take care of what we believe to be the vast majority of these short-term rentals that are operating during specific months and specific activities such as the Sturgis Bike Rally, people that rent out their homes to rally attendees for a couple weeks, get out of town themselves, and then come back after the rally is over. We believe that most of these short-term rentals that are operating in the city limits today would operate under that type of thing. These proposed ordinance changes would allow that to continue without review, without a permitting process required, and that would be what's allowed under state law today. However, short-term rental that is operating for more than 14 days a year would be subject to what we're calling a short-term rental permit. The permit would be administratively reviewed and approved at the discretion of the director, and that decision would be appealable to City Council. And it's what it will be, and that's regardless of the size of the operation, regardless of whether it's a bed and breakfast or as a vacation home rental. However, that is subject to a couple of caveats. The primary one being the size of the operation. So if you have a bed and breakfast that's operating with the property owner on site and two or more not 2 or more, more than 2, so 3 or more guest rooms, then they would be required to get a conditional use permit in addition to the short-term rental permit. That would require hearing before the Planning Commission. You would have an opportunity to take a look at that. With a vacation home rental, it would be 4 or more bedrooms. So if you had a 4-bedroom house or more rooms, and the entirety of that home or property were being rented out, that would require a conditional use permit. And we felt that this was necessary to ensure that when these larger short-term rentals start coming forward, as they have in other communities, the city has an opportunity to review that and take a look to make sure it's appropriate for the neighborhood. We've got, what we hear is that property owners are buying up apartment complexes, or 6, 7, 8 room homes, and starting to operate them as short-term rentals. And what we want to do is make sure that to ensure that those large operations are reviewable by the city, go before a public review process and notification of the neighborhood. However, we still understand that most of these things are not going to be operating in that manner, especially here in Rapid City, and that administrative review and approval would most likely be appropriate in most instances. A typical application will require the same information, same fees as you would typically see. So we're talking about an application fee set by resolution. They'd be required to provide an application with property owner signature, a site plan, an operations plan. We want that site plan to demonstrate that they're proposing guest accommodations which are in compliance with the building code and the fire code, have appropriate egress windows that are going to be safe for guests. They would be required to provide that. Like I said, administrative review and approval taking 14 days, and then action at the discretion of the director, which would be appealable to council. Specific changes in the ordinance, I would direct you to Carla Cushman, city attorney. We can go through that section by section if you'd prefer. And other than that, staff is available for questions if you have them at this time.
Thank you, Robert. John?
Robert, nice piece of work in the background and bringing forth the changes. Do you have a couple of questions? So if you'll bear with me, I'll go through and kind of get through those. Having stayed in a number of these, some of it's just personal experience, and some of it when I was reading through, I want to just clarify my understanding of some of the language in there. Who is the reviewing body?
Mr. Chair?
Vicki?
So when these applications are brought in, staff will look at them and determine whether or not it's just a permit that can be administratively approved, or if in addition to the permit, it requires the review and approval by the Planning Commission, and that goes to the number of bedrooms. 2 or fewer with a bed and breakfast could be administratively approved by the Director of Community Planning, or 3 or more bedrooms or guest rooms for a vacation home rental would require, again, the conditional use permit.
Very good. That's kind of what I thought, but it just never really kind of says that in the proposal. And I like that setup. I mean, I think it's an administrative issue until it gets bigger. Excuse me, I marked a bunch of them, so I'll just go through real quick and not tie up any more time. Throughout the proposal, and this is what I didn't understand, if I was really trying to game the system, I find the dwelling referred to as a private dwelling, primarily a dwelling, and 1 to 4 family. What happens if this is in a townhouse? Half of it's in a townhouse. So I was just thinking about those things as I went through the multiple descriptions of what a dwelling is in this, or a house. So it's just a comment. I don't know that if I was in a townhouse that I want a vacation home by owner next door.
Mr. Chair, that's actually a great comment. I believe our ordinance says that when you look under definition of dwelling, it's a 1 or 2 unit dwelling facility. We'll need to clarify that, because certainly when we were looking at this, we were thinking of a standalone single-family residence.
Then the other thing that I noticed is they're called rooms, they're called guest rooms, they're called sleeping rooms. What if I put a fold-out couch or a cot or something in the living room and create another room? Somehow you need to clarify that you're talking about a separate bedroom, sleeping room, and maybe put a definition in there of what the room is so that you don't find 4 cots in the living room.
Mr. Chair,
Yeah.
before today's meeting, that actually had been a discussion staff was having too, is making sure that throughout the entire ordinance, we reference it as a guest room. And the intent is that if you're using a den or a family room with a pull-out sofa, that counts towards one of the rooms that goes to the size. So we can certainly clarify that to ensure that those get added in. What we didn't want is someone to say, well, I have a den and 3 bedrooms. So I only have 3 bedrooms, so I don't have to get a conditional use permit. The intent is if you're using your den as a sleeping quarter or a sleeping area, that would trip it into 4 areas for sleeping. So we'll look at that too. Thank you.
I noted one comment in there that the conditional use permit fee, the application fee, is $250. Have you discussed, is this a $250 permit or is it another fee? Did you have any thoughts or discussions on what this permit will cost?
So this is something that will be decided by council ultimately. We would bring that forward as a part of the fee resolution. Looking at what we do for sidewalk vendors, staff time, site visits, paperwork, end of things, it's $250 with a $100 annual renewal fee. And that is something that we would require, is that these be renewed annually so that we could track them and make sure that we still have the same people operating the same facilities. At this point, I think we're still looking at that fee.
Okay, and seems reasonable. I'm glad you brought up the annual. You actually suggest you renew them all on January 1st. So I guess you would open up city offices on the holiday and come in and renew those licenses. Probably not. Well, and if I pay $250 because I come in October and then have to renew it in December, is a year over year better just to have the counter, renewing these throughout the year, or is December 31st when you renew everything at the city?
That's typically what we do. Otherwise, tracking these becomes a nightmare. Whereas right now, we have other permits that are renewed starting December 31st, and we can look at the language in our sidewalk vending ordinance. I believe they're given so many days to renew it and still maintain a valid permit. And maybe can't recall off the top of my head how we've got that written right now. I thought we had that in there.
I didn't see it. I just saw that it was December 31st.
I'm looking now.
So, getting near the end. Hang on with me, folks. In places where I've rented, the permit that you are issuing and any state or municipal code is posted. Where I go, if it's in the garage where you go into the house or it's in the kitchen area or something, that posts who it is as the permitting body, so that if people rent it and they have a problem, they know, a little bit about the permit is valid and who to contact. And it also alerts the owner that's putting it up for home. People know that this is a permitted deal. And so posting of that permitting process and any state-required licenses. I never had to use them or anything, but I always felt comforted that I was alerted to that. Kept me a little honest. Tried not to spill as much cranberry juice on the carpet. In page 24, you're talking about revocation of these, which I thought was nice, but it has that notice and then 14 days and appealable to the city council and however that is. It seems a bit complicated, but maybe if it's just people complaining, that's fair to the owner and to the people. But in this society, I noticed that illegal, criminal, those kinds of acts that on their face are under investigation, somebody gets shot, I think the revocation and shutdown ought to be immediate and be provided for in the ordinance. You know, sometimes people just do illegal things. And I don't think waiting for you to post notice and give a revocation period and those kinds of things is appropriate, especially if that place is next door to my residence. So I would urge you to consider illegal, criminal, or whatever other descriptions of actions that the city could go in and the police could take and, you know, shut it down, tape it up, whatever. I think that's it. Can I rest?
You may rest.
You bet.
I would like to clarify that while you were speaking, I did have a chance to go back and read the part about the renewal, and it does give them 30 days to renew it. So
Okay, good.
that hopefully everyone won't be in here January 1st.
Didn't want you to miss the Rose Bowl.
There you go.
Andy?
Robert, I think you answered this question, but I may not have been paying attention. When I read it, my understanding is you can have a short-term rental for 14 days, and that's not changing. That means they don't need to have a tax license or anything. So then, do they need any sort of conditional use? How I'm reading this, they can stay 30 consecutive days, or you could rent it 30 consecutive days without any permitting or conditional use. Is that correct?
No.
When is the conditional use required again? I'm hearing size, and I'm confused on the time.
The conditional use permit would be required when the use, however it's defined, as a bed and breakfast or as a vacation home rental, reaches a certain size. Under that size, it's just an administratively reviewed and approved permit.
Okay,
and then anything under 14 days, no permitting is required.
So anything more than 14 days, and let's say it's a 2-bedroom, that's administrative review.
Yeah.
And then if it's a
Mr.
more than
Chair.
14 days but a 6-bedroom, then it's a conditional use?
So you could rent any size facility in South Dakota up to 14 calendar days per year, not per time, but per year.
Yeah.
That gets us all out of it gets a get out of jail free card for the Sturgis Rally is what that does. And we like that. We really don't want to regulate the Sturgis Rally rentals. So beyond that, if you have 2 or fewer bedrooms for a bed and breakfast or 3 or fewer bedrooms for a vacation home, it's all administrative. Larger than that, you still have to get the permit that you would administratively, but you also have to come before the Planning Commission and get a conditional use permit, primarily because the impact on the neighborhood could be substantial. And we want them noticed, and we want you folks involved in that discussion.
I'm going to interject a follow-up. I saw a 30-day requirement in there as well when I read it. But
If I may.
yeah, that'd be great.
The 30-day requirement is actually in regards to what would be considered a short-term rental. So if you are operating a place where you rent it out for 2 months, 3 months at a time, that's just a rental.
Okay.
We have plenty of places that go month to month with their leases. And those are just rental units, and we don't regulate those. But anything shorter amount of time than that to a single renter.
So it's basically anything that really has a lease or less than 30 days or not a lease at all is what you're considering.
That's
vacation
correct.
rental.
And we looked at language that other communities had used too, because we don't want someone who's renting to college students and they get someone in there every 3 months, they're changing faces. That's not what we're going for here. We wanted to make sure that, you go to rent something, you sign an agreement, you're paying on a 30-day notice or a monthly rate. This is different. These are usually one-time stays, and they're usually for a week or less.
Okay, sounds like you guys have done a pretty good job. I gotta go.
Galen?
Okay, thank you. And I had the same confusion as Andy did on clarifying that when you need the CUP versus when you don't need anything. So I think when this gets presented to the public, make a chart that says here's your duration of stay, duration of rental versus size of house. And then you have your different requirements for what you need. It's just very difficult to wade through this and figure out exactly what we need to do at this point. So I was confused as well on that question. So another question on the ordinance, there's a couple places or multiple places where it says short-term rentals if authorized pursuant to 175340. And maybe I'm not looking at the right piece of code here, but 175340 is like fences and walls. I don't know if that's a misprint or maybe I'm just not looking at the right piece of code there.
To my knowledge, 175340 is the short-term rentals ordinance that we just drafted.
Okay, so that's the new ordinance that we're referring to.
That's correct.
It's on page 22. If you look on page 22, it's being created as a part of this.
Okay, it's being created as part of this, okay.
And you're not the first one to ask that question, Galen, just by the way.
Okay.
Actually, you've pointed out a real problem. There already is a 1750-340.
I'm looking at it.
And yes, you are. It is fences and walls. And so we need to give it a new number that is not already occupied by something.
Thank you.
Thank you, Galen.
Good job.
So I'm not crazy. Good.
Councilwoman Drew.
Yeah, I'm Darla Drew, and I'm your city council representative. I'm just here to monitor and report if there's a problem, and you have a problem. How many of these are we looking at? How big is this? I mean, how many units are out there? What are we talking about? I've heard anything from 100 to 200 places out there. Did you know that?
Mm-hmm. Yes.
This group knows that. Okay, all right, 200 places.
That's correct. But we don't have specific numbers. Like I mentioned earlier, we believe that the vast majority of these facilities are going to operate less than 14 calendar days per year, meaning that they would not be required to go through any of this. But we do recognize the need to protect residential neighborhoods from these very large operations as well. We've seen them popping up in other communities, and they can pop up here as well. So we wanted to make sure that that was being addressed. But in terms of the number that are actually going to come forward, a quick scan of Airbnb will tell you that there's, right before the rally, there's a couple hundred.
Yeah.
Before the holidays, that number can go down to 50, 75. And that's just in the city limits. I should also know that there's several hundred of these operating in the county as well, which this doesn't affect.
Okay, and I'm glad I'm here today for this discussion, just to hear what you guys, your questions are, because this is a big issue for us. We have a situation going on right now in a neighborhood where a bed and breakfast is operating and causing some friction, to say the least, in this neighborhood. So you guys really have to consider what kind of Pandora's box we're opening here, and what kind of stipulations are going to be asked of the people that are operating. Are we going to be able to collect taxes from them, the kinds of things that really matter to a city government? Because, if they're operating under the radar, and it's a really unfair situation for our hotel businesses. So I just be really careful in looking at this ordinance, because it's going to affect a lot of people. It's going to affect a lot of neighborhoods. It's a growing concern. It's a growing business that's happening. I've got nothing against business and people being entrepreneurial, but this has a lot of capacity to upset neighborhoods. And that's my only comments. Thank you.
Mr. Chair?
Yeah.
Darla brings forward wonderful comments, and just a little history on that. It's the very conditional use permit that you reference, where she said in this meeting and identified a large number that she had looked up online that were advertising in the Rapid City area as an Airbnb. And we took that discussion before the Planning Commission and to Council to see how should we be addressing these? What should we do? And the direction we got, ultimately from Council, was that they wanted to see an ordinance where we were creating regulations so that we treated everyone the same. Yet, if you look at these, it does cite different things that they must meet and provide, which gives us the legal grounds we need when we need to deny one. Because these are neighborhood specific. Some neighborhoods can support this use and some can't. So we wanted to make sure that we included all of those items. There will be sometimes we bring recommendations forward indicating that they should be denied. And we wanted to keep you and the city legally covered under those instances. So But yes, a great comment and one we've struggled with too.
Thanks. Karen?
Thank you, Mr. Chair. All these are really good comments and good questions, and I appreciate the discussion also. I have a question as far as if somebody comes in on the internet and signs up to come to somebody's house to stay, it says in there if there's a vacation home rental with 3 or fewer guest rooms, it doesn't need a conditional use permit. It just needs to have a... What if 3 separate people want to come and use 3 separate bedrooms, and then you've got 3 cars? Is there something in here that says you can't do that, or?
Well, the ordinance is written to be specific to the number of rooms rather than the different number of renters. And the parking that it's addressed, again, it's a different calculation based on whether it's a bed and breakfast or whether it's a vacation home rental. But in your example, you've got a vacation home rental with 3 separate guests staying, then each of those guest rooms would be required to provide 1 parking space. A parking space in this instance is defined as bays in the garage or spaces on the parking apron in the driveway. No on-street parking may be calculated or considered as a part of the parking that's available for a site. So if they want to operate 3 bedrooms, they better have 3 combined spaces off the street, in the driveway or in the garage, available. They would need to demonstrate that as a part of an application.
Okay, and so if their intent is to just have 3 bedrooms for a family, then in that instance, and that's what they say, but in reality, if they start doing other things, then the neighbors would have a chance to complain and you could revoke their permit?
That's correct.
So if they had 3 bedrooms available as a bed and breakfast, that would be a conditional use permit.
Right.
And they could have 1 person in each bedroom, as Rob indicated, or they could have 2 or more in each bedroom. But the intent is for the most part, if everyone's sleeping in that same bedroom, they're probably showing up in the same car.
Yeah, yeah. And then the other comment that Darla made about the taxes and how that's probably not something that the city can put in an ordinance, but how do people track that?
Well, one of the review criteria, one of the submittal requirements as a part of any application is that they show that they're licensed with the state, all state regulatory agencies, which would at that point require them to have their state tax ID and their lodging license.
Okay, and that
they
is
would need to bring that in as a part of their submittal to us, so they would need to secure that before they ever came to us.
Okay, and that is in this ordinance?
That's correct.
Okay, I missed that. I'm not real good at reading things on the screen, so I missed some of the things, but thank you. It's a good start, and I hope that it solves some of the issues that are out there. I know that it's an issue for some people, so thanks.
John again.
Thank you, Mr. Chair. Just a quick question, if I may, of Vicki. Is this going to come back to us or go to the council for their discussion and then come back? We don't see the ordinance that's going to be recommended to the council yet. A lot of good discussion today and points of clarification. So will this come back to us?
We can bring it back to you. This is our draft, and we can certainly make the changes as we've discussed today and bring it back to you. Probably not next meeting, but the following meeting. I don't know, Carla, she's the one that's put in the energy on getting this on paper, and we really appreciate the effort she's put into this.
I think it's a great foundational document, a lot of stuff clarified in it. And then just one thing on the application, based on some of the questions people asked about size and number of rooms and whatever, they're trying to clarify whether they need to be documented. At least a yes or no question. If people are advertising on Airbnb or Vacation Home by Owner, that ought to be a question on there, because that is an advertisement for those, whether they say they're under 14 days a year or not. It's out there. So, and that is the way that those get rented, I'm presuming, about 99% of the time. Anyway, those are my comments. Thank you.
Thanks, John. Steve?
Yeah, I want to thank you for the work you've done, too. I mean, it's not going to be perfect. There are always going to be challenges with this, but at least we're starting somewhere and we're going somewhere. And to give an example, my brother-in-law was staying in a B&B, and and I was down there staying in a hotel. We all converged on there's 10 of us that converged on, on their location. So as much as you try to do parking, you're going to have issues where people come into town. It's no different than right now if I have a barbecue and I have 10 people show up. When we were there, the neighbors got upset because we were parking on-street parking, and they called the cops, and the cops came out, and we were legally parked. We were visiting them who happened to be staying in one of these locations. But again, I say it's no different than if you have a barbecue and I have 20 people over and they take up the neighborhood. There's nothing we can do about that. It's going to happen. But at least we're taking a look at trying to protect the neighborhood and on an ongoing basis. If there's 150, 200, whatever they are out there, at least we're moving in that direction. So I just want to say thank you. And there's no way you're going to fix all the problems. It's just not possible. But thank you for your efforts.
Mr. Chair?
Yeah.
Part of the application for the permit, and the short-term rental permit is required across the board. If you're more than 14 days, you have to get the permit. We not only want to know how many guest rooms are available, but what's your maximum occupancy you're going to allow? And on vacation home rentals, where the owner of the facility is not there, it's also in here putting them on notice that they are still responsible for maintaining that maximum number on site. And again, what that does is it gives us grounds, if there are continued complaints from a neighborhood, that we can come back and bring a revocation to the Planning Commission for consideration.
Thanks, Vicki. I had one question. This, at the start, Airbnb, their foundation was renting out rooms in places that were already rented out, apartments in San Francisco. And from that start, the owners of the buildings didn't care. That's changing for sure, but there's still a lot of probably leased houses that are being rented out when the lessee is not there. We don't have, other than the rally, as much of an event-based season as some other cities, but I just think of a friend of mine in Austin. When South by Southwest comes to town, they put their leased apartment up, and the permitting, it requires the property owner to sign, but does the property owner have to be the applicant in that case where they don't care?
No, that's a good point. You are correct. The property owner has to sign any application. So anytime one of these is operating, it's operating supposedly with the owner's knowledge, but the applicant could be a lessee or a tenant.
Okay.
So we've identified that there's an owner and potentially a different operator, and they would both be responsible for the operation of the facility.
Does that jive with other applications? I'm thinking like a liquor license.
Any development application you look at is authorized by the property owner.
Gotcha. Okay. Thank you. A lot of good discussion. I kind of agree with John's take that we might need to see a revision of this, unless anybody feels differently.
We can certainly bring it back to you, Mr. Chair, and that might let us kind of have some internal discussions too. And sometimes we work on it so long, maybe we're reading things into it, and it helps us when you read it and point out what you find confusing, because certainly we want it to be as clear as possible when we bring this forward for implementation.
Look for a motion. Huh?
We are, but if what you would like to do is make a motion for staff to revise the document per the discussions today and bring it back before the Planning Commission, that would be.
That's my motion. Thank you.
Great.
So putting it so.
As far as timing, Carla, would you have a input in timing of that motion?
I would say in 2 meetings, just to make sure that we make that we have enough time.
Perfect.
And make sure that we,
That work
have
for
the publication as well.
John, Jan, work for you? Okay. The motion on the floor is to continue this for 2 meetings.
September 22nd.
September 22nd. All those in favor of the motion, please say aye. Aye. Opposed? Motion carries. Item number 12. You stuck with us, Patsy.
Good morning. The applicant has requested that this item be continued, I believe, to the 22nd of September. It's on your agenda summary page.
Motion has been made and seconded. Patsy, do you have anything else to add?
I just want to show you how to get to the tax increment stuff on our website.
That would be great.
So, if you wanted to make that motion, I'll get our website up.
Okay. All those in favor of continuing this to September 22nd, please say aye.
Aye.
Aye. Opposed? Item number 12 is continued. We'll go to discussion items. I'll let Patsy continue to work. I just want to welcome John to the commission. He's going to be a good addition. Happy to have him up here.
Welcome back to the zoning board.
Yes.
So quickly, here's our website. The easiest way to get to the tax increment information is go to meetings. And then down on the right-hand side is boards, commissions, and committees. So if you're generally looking for any kind of committee that's not one of the four main committees, Planning Commission, Council, Public Works, Legal Finance, you can find all of our meetings under this little link. Then you scroll down, and they're all in alphabetical order. Tax increment financing is generally on the bottom of that list. You can get to the agendas, the minutes, and the most critical pieces are this spreadsheet that identifies our existing history on what our tax increment districts are generating, what kind of revenue, the status of the active districts. You can also get to all of that history where each of the plans are listed. They're in numerical order. And then you can also get to the active district map. And again, go to our homepage, meeting, boards, commissions, and committees, and then any of the committees are listed right there.
Steve.
Yeah, I've done this quite a few times, and I get a lot of error. I get errored out on the. And sometimes where it populates the government, all that won't show up. And yesterday I was trying to get on there, and then today when I got here, I got errored off a couple times, and I finally got on. So I don't know if we're having problems with our system here, but it's not real smooth running, and I get errored out more than I get on, I think.
Okay, we will share that with our IT folks, see if we can get you an answer.
Thank you.
Thanks, Patsy. Karen?
Thanks, Patsy. The history, is that the same history that we had previously? I mean,
it just looks differently. We can't do a chart like we had before. So when you go through it, let's get to that down again. So the tax increment history. So as you click on it, there was no project plan for tax increment District 1, but 2 has a project plan. You can pull it up and look at the information. So it's out there. It's just in a different format.
Okay, I'll have to look at that. And to me, I was trying to look for that the other day, and I never thought to go to meetings. I went to the planning department, and then under there was something that showed each project plan, but it didn't have all that other stuff in there that I could see. So I was confused.
We are still working on the department webpage, so, you know, there's still a few tweaks that we need to.
I would think that anybody that is going to look for tax increment things, so wouldn't go to a meeting. I mean, that's just my comment, so you can pass that along. Thanks, Patsy.
We have a staff item for a training update. I requested this just due to the new state law, but I would ask that we do it on a shorter meeting. If that, since
I
we're
was
at
going to
8:30
suggest
already.
that too, and give you a break from hearing from me. I think Vicki said next meeting looks to be like a short agenda, so
Okay.
that would be appropriate.
Perfect. Any other items?
Move to adjourn.
We would like to welcome John Hurt to Planning Commission. Thank you for joining us, John.
All right. Steve made the motion to adjourn. Jan seconded. All those in favor, please say aye.
Aye.